Man, hopefully that story YouTube doesn't capture before I said that. I
Can't imagine Rob doing that.
Oh, heavens, no. I mean, man, hopefully that story YouTube doesn't capture. All right. Are we still live? Let me make sure it is not. My audio is off for YouTube. All right. We are live, but I think I have my audio recordings. Hold on one second. You're not with me. I am in an all-day Coke County. Judge Walther is hearing my pleas. Renee will probably just ring the buzzer for Renee, and she will try to get you. You'll have to be on Zoom. So I'm sorry. I thought you picked up on that Monday when I was doing pre-trials. I'm sorry. My Schleifer district clerk just walked in, and I thought, what is she doing here? She's. I don't have anything for them today. All right, let's get going again. And I think what I indicated we would take up next is the motion to exclude Deborah Sport Moore. And so Mr. Addison or Mr. Knight, whichever one of you is covering this one, may proceed.
Thank you, Your Honor. Right, we filed a motion to exclude. I might add on all of these, we've moved to exclude the reports. And I'm not sure there's an objection to that. I haven't seen an objection to that, but we lay out in each one of these the law that sort of governs that. And as the court, I'm sure, knows, that's a complicated area because of the ability to rely on hearsay, but it can't be admitted. But in any event, we are moving to exclude all the reports of each one of these folks on that basis. As to Ms. Moore, our concerns about her are about fourfold. Number one, she repeatedly gave opinions outside of her area of expertise on topics for which she was not qualified. And we've collected those at Exhibit D to our motion. And I'm not going to go through those in any sort of long format, except to say that she has a number of areas where she gave opinions where she wasn't qualified. And then secondly, in Exhibit E, we have a listing of those opinions where she lacked sufficient certainty or probability. And she just said things might appear, they appear to be this, and the like. And as is set forth in this particular motion, we walk through why none of those should be admissible. Other than those general sort of statements as applicable to each instance, there are really three issues that we're attacking here. One is this particular expert only investigated down to 10 feet, and she only investigated soils down to 10 feet. And admittedly, Your Honor, you might say, well, Mr. Addison, that's just ripe for cross-examination, and so go about it that way. But she makes conclusions about the entire site, and all she has done is go down to 10 feet. And a good example of that is listed on page 21 in our Exhibit E. And
give me just one moment.
It's the very last exhibit in our report and makes up the last 3 pages if you're going after it hard copy.
All right. Yes, sir. All right.
And by way of example, that second bullet point, she says, based on the soil sampling performed by Sport Environmental, it would appear that only an extremely limited portion of the subject property may have soil with chloride concentrations in excess of 3,000 milligrams per kilogram. That's another way of saying parts per million in a solid measurement. And the point there, Your Honor, is that she can't say that because she only went down to 10 feet. She knows nothing about the soils at the site below 10 feet. We have evidence from Mr. Hughes that there could have been an outbreak at 400 feet. No one ever investigated that. I might add, Ms. Moore admits that she doesn't know of anyone for any company, for any expert who investigated soils lower than 10 feet when they stuck a packer in there at 260, and at 3736, they had squeezes where you address integrity issues in the wellbore at other depths, and no one went there. So her opinions with respect to 10 feet, as I mentioned, Your Honor, if you want me to cross her on it and that's just weight, I can understand that, but they're really harmful and they're irrelevant because 10 feet is not even the ball game. And unfortunately, you know, for Memorial, they only cleaned up to even shallower than that, 3 feet. She claims in her report that she's gone the extra mile by going 10 feet when there clearly is potential contamination down to almost 4,000 feet. So she really shouldn't be able to give those opinions. She should be limited to her opinion. And in reality, her opinion doesn't assist anyone. It doesn't tell us anything. So what? So nothing was down to 10 feet. What about the other 4,380 feet? And so we object to her on that basis. We don't think she should be able to give that opinion. That opinion, however, is not the take-home end-all deal. And the take-home end-all deal on this is her 3,000 parts per million soil standard. And Your Honor, you're about to encounter a really complicated issue here that I guess we all are going to have to sort out. But in all of these cases where you have something other than a cleanup under a regulatory agency, the standard is not the same as the cleanup standard. And so what you find here is that there was a standard of 3,000 parts per million that the Railroad Commission uses generally for chlorides in soils. Now, I might add, within that letter we talked about earlier, there's a provision that says if you have sensitive receptors, you need to look at a soil standard that's lower than that. No one ever did, although ETEC and Memorial concluded because of the cattle, there were sensitive receptors at the Cedar Mountain Ranch. So the entire 3,000 part per million standard, which is driven by the Railroad Commission, is not even ipso facto the right standard. Now, that's a different issue. She uses 3,000 parts per million as the standard to determine the lee's damages. She tells me in her depot that the lee should be satisfied with that. She testified that this is a Railroad Commission matter and that they control the standard. And so with regard to that opinion, Your Honor, let's turn to the exhibit that I believe is the last exhibit we offer up, which is the case of Forest Oil Corporation versus El Ruccio Land and Cattle Company. And when the court has that before her.
Hold on, let me see. Is that in your notebook? It may be in your notebook.
Yes, Your Honor, it is an attachment to our motion. It's the last exhibit in the motion to strike or to exclude rather, Ms. Moore.
All right, here we go.
And I'm sure we've got it and can pull it up if it's not conveniently found.
I have it. Y'all sent me one binder that had all the cases, and so I've got it right here.
Okay.
Give me just 1 second to get to that number 8 tab. All right, I am there.
Now, what this case is taking up, Your Honor, is when you have a private party lawsuit like ours, whether or not the regulatory standard, whatever that is, and here it's 3,000 parts per million, governs the cleanup and the damages for that private party lawsuit. And where the case really begins to take up the issue is if you're looking down at the bottom corner on page 6, Roman numeral 2A.
All right.
Okay. And what the court first takes up on that page is whether or not the Railroad Commission has either primary or exclusive jurisdiction over this lawsuit. And the court walks through that. And over in the right-hand column, in that first complete paragraph, they talk about it. It says, Forrest argues that the Railroad Commission has exclusive jurisdiction over this dispute, foreclosing McAllen's common law contamination claims so that the arbitration panel lacked jurisdiction to enter the award and the trial court the jurisdiction to confirm it. And what that goes to is the issue of whether you use this regulatory standard. And then the Supreme Court says, abrogation of a common law right, as we have said, is disfavored and requires a clear repugnance between the common law cause of action and the statutory remedy, a statute's express terms and the like. And so they set that up. And at the end, the Supreme Court says, absent such a clear indication, the Railroad Commission did not have exclusive jurisdiction over the claims at issue. We go back and we go down a little further, and I think you have the version that is highlighted, Your Honor. If you look down to the bottom of that paragraph to the last highlighting in the right-hand corner, they're talking about all the laws, the TCEQ, the Railroad Commission, and they say, it does not exclude judicial authority over common law claims. Forest cites statutes authoring the Railroad Commission to regulate hazardous waste, but none of those provisions remotely suggest, let alone clearly indicates, that the Railroad Commission's authority is intended to be exclusive of common law actions like ours. So you then go over to the next page, and there's some portions that you can look at that are in the highlighting the first two sections that walk through where the court's headed. But the last highlight is the take-home point. And what it is in the holding of the case is McAllen's common law claims are not dependent on the standards of regulatory compliance. The 3,000 parts per million standard, Your Honor, is for regulatory compliance. It is not the measure of damages, as this court already knows. The real property damages are measured by the difference in the value, if it's permanent, or it's measured by the cost of the cleanup. If you look at the other causes of action still in play, like nuisance, their measure of damages doesn't talk about 3,000 parts per million. So the regulatory standard is irrelevant to our damage claim. Now, here's where the complexity is going to come in, Your Honor, two ways. Number one, I'm going to walk through Ms. Moore's report, and she is more tightly wedded to this 3,000 parts per million standard. She said the Lees ought to accept it. It's, you know, that she says the Railroad Commission governs it. She said Pat Gobb's analysis of background doesn't even matter because of this standard. All of her opinions are tied to the 3,000 parts per million standard, and so they have to be excluded. That is the wrong standard completely. It's not even in play as to the damage model under this case. I might add, Your Honor, this is a 2017 case. This was a huge deal. Everybody that's litigating environmental claims was litigating, if I only clean it up to 3,000, am I in the clear? Or do I have to clean it up to these other standards that are in common law? So when this came down, this is huge. It changes the game in every one of these cases. And so she isn't entitled to give an opinion that by going to 3,000 parts per million, Memorial, anybody else has satisfied the standard for damages, because it has nothing to do with it. And that's exactly what this holding says. Now, she should be excluded on that. There's no question about it. You cannot have a Supreme Court case that outlaws your testimony and then put it into evidence. Here's the complexity for this court. And I got to tell you, I do not know of a court where it has been resolved and there's a decision on it. In all of the materials, e-text materials, The standard that was used is 3,000 parts per million, and it's going to be allowed to be talked about. We're going to criticize it. E-Tech is allowed to put their reports in that say, hey, the Railroad Commission told us to go there and we went there. They're not allowed to say that constitutes what measures your damages. And, you know, I've thought about this, Your Honor, and how we handle it, because it's incredibly tricky. E-Tech is saying we hit a performance standard. They're not given an opinion on whether or not that performance standard governs damages. On the other hand, Ms. Moore is a testifying expert. Her opinions are not in a report that is created in the ordinary course of business and is a part of a cleanup. She's retained to give opinions here. She has no opinions to give. The evidence concerning E-Tech, I cleaned it up to this standard. We're going to attack that. We're going to show it's not the right standard. But her being able to give an opinion that it was the right standard is totally contrary to the law and can't be allowed in. It's not only prejudicial, it would be automatic reversible error under this case. So that's really the most important issue. As we note in Exhibit E and D, Ms. Moore's way outside of her area of expertise. She's given opinions. She gave an opinion that the cattle looked healthy based on one of her subordinates taking a picture of it when they were at the ranch. She gives an opinion on ranch management. She gives an opinion on soils below 10 feet. So there's really, her failures permeate her report. And then they're all couched, as we note in Exhibit A, Your Honor, in the language of what appears, what is likely. Another area of speculation we had to devote time to is she goes out and in her report, and this is addressed both in the body of the motion and in the exhibit, but she raises two landfills. And she acts like these landfills, kind of like everybody talked about how the Coleman Formation was going to come over and jump down the well. In the same way, she raises two landfills that have a regulatory entry that said they might be permitted. They could be permitted. They were never permitted. There's no evidence they were ever permitted. She creates it out of whole cloth. And she comes in and says the plaintiff should have investigated this as a source. And so she got cross-examined on that. And it demonstrated her opinion in that area was so far afield and so baseless that you question her whole reliability. She's given out opinions on every topic. How can you select one within her area of expertise and believe it? It's just another opinion she gives. And when you read the entirety of our motion, that comes out in spades. She talks about a mining operation because she saw flecks of metal on the ground. That kind of stuff is not scientific, and it permeates her report, as I mentioned. In closing, I think that covers, I might add, I left out one quote from the Forest Oil case. I gave you that last one where it said common law claims are not dependent on the standards of regulatory compliance. Also at page 430, the court held, while Railroad Commission regulation and orders certainly informed the extent to which remediation of contamination is required by law, they do not supplant forests' common law duties, which are also required by law. And so her opinions aren't admissible. They don't have sufficient probability. She's not qualified to give many of them. And we would respectfully suggest she should be struck, excluded, along with her report in her entirety.
All right, thank you, Mr. Addison. Who is going to argue in connection with Ms. Moore for the defendants?
I am, Your Honor.
All right, you may proceed, Ms. Oscarson.
Let's start with the Forest Oil case that the plaintiffs cite. That case, Your Honor, does not address at all whether or not the Railroad Commission standard for contamination in soil matters in a case. What that case says, and all it says, is that the Railroad Commission does not have exclusive jurisdiction over contamination cases. It's saying that the Railroad Commission, well, that you don't have to exhaust administrative remedies at the Railroad Commission before you can bring a lawsuit in court. Those things can proceed parallel. And it's important to note that before this opinion was authored, or I guess I should say at least before the case proceeded in the trial in arbitration, the Railroad Commission hadn't approved a remediation plan. And the oil company wanted the arbitration to wait until the Railroad Commission finished its investigation, and then perhaps they could proceed later, kind of like in other administrative law. And the Supreme Court said, no, that's not what we're going to do. These things can proceed on parallel tracks. Nobody raised in the Forest Oil case whether or not the Railroad Commission standard for cleanup was the appropriate standard, whether that was a reasonable standard for cleanup. It's not, this case does not touch on it at all. Ms. Moore is not opining that this lawsuit shouldn't exist right now. She doesn't say anything about whether or not this court has jurisdiction to hear this case. She says nothing about administrative remedies, and honestly, she probably doesn't even know that that's a thing in the law. She's saying that the Railroad Commission has set forth what is a reasonable standard for cleanup in this state. That's like I said, that's not even addressed in the Forest Oil case. And I'll point the court back to page 7 of the case where Mr. Addison just read, and immediately before Roman numeral 3, Mr. Addison highlighted a sentence from that case, but it's important to read the sentence above that, because in this particular case, the parties had a surface agreement. These people had gotten crossways prior to this dispute, and so to settle their prior dispute, they entered into a surface agreement. And the landowners wanted their surface agreement enforced. Their surface agreement provided for a different standard than the Railroad Commission standard. That's not in this case. The court's already ruled there are no agreements between the plaintiffs and Ivory and Memorial in this case. So when we go back to the Forest Oil case and we read this whole thing, the Railroad Commission's determinations of forest obligations under its rules do not preclude enforcement of forest obligations under the surface agreement. McAllen's common law claims, meaning its contract claims, are not dependent on the standards of regulatory compliance. So it's not the same causes of action that we have here, Your Honor. Forest Oil just doesn't apply. But what does apply are the cases that we cite in our motion, which say that the that the state action levels are the reasonable levels to which remediation should happen. The Easy Mart versus Holland case and the Taco Cabana versus Exxon case are actually cases about contamination and cleanup. And both of those cases say that unreasonable levels on land are the levels which exceed state levels. Those are directly on point, and those say that in this particular case, 3,000 parts per million would be the reasonable level. And so not only did Ms. Moore testify, not only is her opinion relevant, it's actually what these two cases say is reasonable. So she should be permitted to testify to that. Now, turning to the landfill, my recollection of her testimony and opinion was that she did some looking in the Bront City records and determined that 2 landfills were permitted for the Cedar Mountain Ranch. One landfill was not built. She found evidence of the permit, but never any additional evidence beyond that. The other, she determined, was permitted and was built. And when she was out on the Cedar Mountain Ranch in 2019, she could still see the remnants of it. She could see when the sun hit the ground, broken glass and pieces of trash that were still present on the Cedar Mountain Ranch in 2019. And so it's absolutely relevant and material when the Lees have testified that this ranch was pristine prior to the surface breakout in 2014. When they bought their ranch, though, a landfill existed on it. To the concern about her testifying regarding the health of the cattle, she admitted in her deposition she's not a veterinarian. She doesn't know if the cattle were healthy or not, but when she was out there in 2019, she observed cattle on the Cedar Mountain Ranch. But the plaintiffs have testified that that ranch is totally unsuitable for cattle. So she can testify to her observations that there were cattle there. Now, healthy or not, she's not a veterinarian, she doesn't know, but she can at least testify she saw them there. Now, turning to the 10 feet down and all about that, it is not the defendant's burden to prove any contamination exists or doesn't exist on this property. As we have these experts as our defense experts to prove that the land is not contaminated or it's been remediated. But whether it was ever contaminated at any level is certainly not our burden. Ms. Moore examined the property to 10 feet deep, and she is certainly qualified to testify to what she sampled and what she observed. She has reasonable reasons for going to 10 feet deep. At 10 feet deep, she determined that the contamination had stopped at that level, and so she felt she needed to go no deeper. But the fact that she didn't go all the way to 4,000 feet or 400 feet or the center of the earth is not her burden. It's the plaintiff's burden to prove there's contamination down there, if there's any, not ours to prove that there isn't. And so she should certainly be able to testify as to what she studied and observed and tested, which was 10 feet in this case. And that's all I have on that, Your Honor.
All right. Any of the other defense counsel? Yes, Mr. Brown.
Judge, I'd like to weigh in and springboard from what Ms. Oscarson was just saying. And with any luck, I'm going to be able to adequately share the screen. In addition to it not being the defendant's burden of proof to show what's not there and plaintiff's burden of proof to show what is there, Mr. Addison made a point in his presentation today and in a rather lengthy colloquy in Ms. Moore's deposition that he was asking questions, but what about below 10 feet? And she kept answering, I tested to 10 feet, and here are my conclusions. Well, what do we know about what the plaintiff's experts have tested down to? And let me see if I can get this up on the screen. Here it is. Are you able to see this, Your Honor?
Yes, sir.
Okay, this is page 42 of Patrick Gobb's original expert report in the case that was issued in 2018. And if you look at paragraph 5.1.2, soil sampling, here's what Mr. Gobb says he tested down to. They took 27 shallow soil bearing locations down to 6 feet below ground surface. That's what's being referenced in that second line. And 6, what he called deep soil boring locations to a depth of approximately 10 feet below ground surface. That's Mr. Gobb, their environmental expert, who's trying to support their burden of proof that the soil is contaminated to whatever level they want to say it's contaminated to. And Mr. Gobb took 33 soil-bearing samples, none of which were below 10 feet. In addition, next thing up. Let's look at what Mr. Farley, the ranch management man, did with respect to the Haney soil sample testing. Let me figure out maybe how to minimize. Did I minimize this too much, Your Honor?
No.
Okay. If you come down to the paragraph, and this is page 2 of Mr. Farley's only report in the case, he's talking about the Haney test. And this paragraph that begins the Haney test or soil health test, you go down about 5 or 6 lines. We drilled 2 samples 6 to 8 inches deep and drilled 2 holes 6 to 8. It doesn't say inches or feet, but I'm going to represent to the court that the other 3 places where 6 to 8 is referenced, it says inches and not feet. There were, in this paragraph, a total of 8 holes in 4 locations, sampled to a depth of 6 to 8 inches deep. And so for Mr. Addison to come in and criticize Ms. Moore for giving an opinion about, she doesn't have any opinion below 10 feet, and therefore she should be stricken, doesn't seem to make sense. And it's not the, as Ms. Oscarson said, it's not the defendant's burden to do that. And as I've just demonstrated from the plaintiff's own expert reports, they didn't go any further below than 10 feet. And so to suggest that somehow Ms. Moore is unqualified for not going below 10 feet just should not pass muster. The other thing that I'd like to show real quickly, a discussion about the Railroad Commission standard of 3,000 parts per million, and whether there was any agreement with the operator Memorial. Ms. Moore testified. Let me see if I can pull this up. Ms. Moore testified, and this is on page 63 and 64 of her deposition. And are you able to see that, Your Honor?
I am.
So Mr. Addison asked the question, have you been in other cases where with respect to the remediation of chlorides, there was a standard either below or above 3,000 parts per million? Answer, yes, if the surface use agreement dictated so. Question, you reviewed the surface use agreement here, didn't you? I did. To the next page, and you didn't find any particular performance standard included in this surface agreement, did you? No. And then question, and in fact, kind of in fairness, the 3,000 part per million is a standard the Railroad Commission uses in basically every case if there's not an exception, like what's in the surface use agreement. Answer, you see it primarily within the OCP program out of Austin, which had jurisdiction over this particular case. And the deposition goes on. The point being that there was a surface use agreement between Memorial and the plaintiffs that in fact was entered into, I want to say, maybe early 2014 or late 2013, before the surface breakout, and there was no reference to any sort of background level, any sort of necessary cleanup level, and so Ms. Moore is entirely appropriate in relying upon the Railroad Commission standard, 3,000 parts per million. Those are the three areas that I wanted to add a little more substance to with some of the documents and evidence, and I'll stop now.
All right. Anything else, Mr. Terrell? Anything on this witness?
No, Your Honor.
All right, Mr. Addison, let me come back to you.
Just a couple of points, Your Honor. Mr. Farley is not giving opinions on soil contamination to any depth. He's analyzing topsoils, grasses that grow, and the like. He didn't need to sample any deeper to determine the topsoil, and he walks through what the topsoil goes down to in his own deposition. And so the notion that because Farley didn't sample any deeper, that makes Ms. Moore's sampling relevant or meaningful, no. Number two, Mr. Farley isn't asserting a level of performance that determines the cleanup and the damages like Ms. Moore is. That's the problem with her opinion. Secondly, as to Mr. Gobb, Mr. Gobb's not giving opinions on soil. He's giving opinions on groundwater. He samples the soil to find out what's moving into the groundwater. And as we've stated throughout, Your Honor, there were incredibly high chlorides in the soil that the experts at ETEC recognized are, quote, percolating down through the soil to the groundwater that were never removed, even though Memorial said they would. That's why you look deeper. You also look deeper because there may have been a release deeper, as the evidence shows. So Mr. Gobb's role is not a soil role. He's not sampling the soil to determine how it's been cleaned up. He's looking at the constituents as you go down at depth. The burden of proof is a red herring, Your Honor. We've got the burden of proof to prove the case in our damages. They've got the responsibility to perform a cleanup that allows them to put into evidence a measure of damages that is applicable. This measure of damages isn't. She can't give an opinion on it. As to Ms. Oscarson's stuff about these other cases, this case is cited throughout the state as the case that determined the regulatory limit doesn't apply in a common law lawsuit, period. It is a 2017 Supreme Court case that went to the court to resolve that issue. And so the notion that there's some other decision where they performed a cleanup under the Solid Waste Disposal Act and they used a regulatory standard is inapplicable here. The oil case we're looking at goes to what's the standard in a common law action. Turning back to that, it has nothing to do with a regulatory standard. You have to go either find out the difference in property value, you have to go find background. Why are we looking for background in groundwater? Because we're looking for the applicable standard. That's the applicable standard. The soil is just a function of what's going to go in the groundwater ultimately. That's why this ranch is dead, is because they didn't clean up the high chlorides. All of that material will end up in the groundwater. That groundwater, like Mr. Gobb says, will not be cleaned for a very, very, very long time. Ms. Moore's opinions are just inapplicable, they're prejudicial, and they're just flat wrong. Now, they mentioned Ms. Moore and a number of points, and I do want to mention what she testified to when she was under cross-examination. She, on several occasions, tenaciously defended the 3,000 parts per million standard. And when asked about it at page 60, 64, and 96, she asserted that by blending the soils to 3,000 parts per million, Memorial's remediation is, quote, complete, quote, because the Railroad Commission has jurisdiction over oil and gas operations. Well, they do, but they don't have jurisdiction over this lawsuit. Next, at page 46, I asked her about the standard and she testified about the 3,000 parts per million, and totally inappropriate. I think it should satisfy the lees, but it definitely satisfies the Railroad Commission because that is the standard they use under the oil field cleanup program. Also at 47 to 48, she says, I feel like the way E-Tech addressed that soil cleanup was appropriate. That includes the blending of the soil that contaminated more clean soil. That includes their never bringing in the clean soil they said to. That includes them never removing soil that was as high at one point as 30,000 parts per million chlorides. They left it there, they diluted it, and they declared victory. And she is the linchpin on that. By using the wrong standard, she disqualifies herself. She also admitted at page 96 and 97, and this is important because I asked her, did you use any other standards? Did you ever look at any other standards? Did you ever look at a legal standard? And she said, no, didn't need to, didn't consider legal or other standards because of the 3,000 parts per million standard. So that was Ms. Moore's testimony on that issue. And as the court can see, she's just dead wrong. The notion that that 3,000 parts per million standard could be injected into the case as a damage element or a determiner of damage is unsupported anywhere. And it was resolved in this case. Now, what we come back to, Your Honor, is the complexity of the evidence, because the 3,000 parts per million standard is all through these documents, and we're prepared to handle that. What we aren't prepared to handle is this opinion that that governs damages, because it doesn't. So once again, no case law to support the position that the Railroad Commission standard applies in a common law lawsuit anywhere after 2017 that's applicable. This case is the take-home case. Ms. Moore doesn't come near it, and she has to be excluded from giving that opinion. Thank you, Your Honor.
Right. I'm trying to wrap my mind around formulating a question on this, because what it sounds like to me is, and I want to be sure I'm following you, that 3,000 number is going to come up as far as that's what the Railroad Commission from the regulatory standard is. But what plaintiffs are arguing is that the ultimate opinion as to damages should not be the 3,000, because it's y'all's position that that's not the level. The 3,000 parts per million is not what would put the plaintiffs back in the position they were prior to the outbreak. Am I following you? So it's almost kind of falls into the made whole doctrine. You could get the car running back on the street again, but if it still has no paint on it, you aren't in the same place you were before the accident happened.
Correct, Your Honor, but what we're really basing this argument on, we do argue about that being the standard and that we don't think it's correct. Here, what we're saying is that the Supreme Court decision says whether it's 3,000 parts, whether it's 12 milligrams per liter, the regulatory standard doesn't govern the damages.
That's
because
not,
it comes out of an agency, because it's not the jurisprudence of the law. And that's what the Elliott case decides squarely when they say that the regulatory standard has no place in the case.
I think what I'm trying to start thinking through is the issue of the fact that the Railroad Commission, what I'm hearing, may have allowed Memorial to clean to that until they got to that 3,000. That's going to come into evidence regardless. It's more the issue of someone giving a definitive opinion that that's all that was required.
That's exactly right. And that what was all that was required came out of an agency rather than out of this case through these experts.
Okay. All right. I'm with you. I follow what you're arguing. Just want to be sure I wrap my mind around that correctly. Since this issue of it's going to come in, the number is going to come in, making sure that when I rule on it appropriately,
In your honor, I want to respond to that last point. We're prepared to cross-examine everybody on our disagreement with the 3,000, with all of those issues. And we can handle the fact that it's going to come up repeatedly. And we're going to say, you know, that's great, you did that, but that doesn't get you here. It's different when an expert's going to come in and give an opinion that says, hey, this is the end all standard. And by doing it, you have no damage.
I follow.
That's it. Thank you, Your Honor.
Your Honor, can I make one observation that goes to, I think, your concern about the practical consideration? In our proposed jury charge, we have included a proposed special instruction to try to deal with this issue. I don't know that it's going to get there entirely, but just to let you know, this is on our radar as far as some of the practical considerations. And we appreciate the fact that if the court ultimately agrees with us, we are also thinking about how we might be able to assist with some kind of satisfactory resolution.
All right, thank you for bringing that up. All right, let's go to our last challenge to one of the defense experts, and that will be the challenge to Andrew Burleson. Mr. Addison, are you addressing that one, or is that Mr. Knight?
No, I'm afraid, Your Honor, you've got me on all the motions to strike, and Nolan's the defense. With regard to Mr. Burleson, I got along with him, I want to say, and we had a delightful time together, but his nature and his whole position is kind of summed up in our quotation on page 2 of the motion to exclude Mr. Burleson.
Yeah, okay, I'm there.
And you'll see there are 2 quotes. And this was his position on causation, on the Wellbore condition, and the like. And he says, I can rule some things out, but I can't connect the dots to say, you know, this combination of wells. I can point to some things that are likely occurrences that could help the explanation. But unless you can trace fluid, are you ever really going to know how it happened or where it came from? And I followed up and said, you're really giving us an opinion on these possibilities and likelihoods for causation, but you haven't been able to conclude exactly what caused the surface breakout at the Cedar Mountain Ranch. And his answer is, that's correct. We could stop there, but why? Let's go to his opinions just so we'll have covered them. What Mr. Burleson does is he ties himself to his own standard. And that's on page 3 of our motion. And it starts there at the top with a case from the Supreme Court and a holding that when an expert's opinion is based on assumed facts that vary materially from the actual undisputed facts, the opinion is out without probative value and cannot support a verdict or judgment. Well, Mr. Burleson had 7 opinions. In the 7th opinion, he writes that as a part of his opinion in this case, pressure monitoring is the only method available to effectively evaluate maintenance of either the injection confinement or the integrity of the tubing casing annulus in an active injection well. And those 2 components are important to us. When he says maintain injection confinement, we went through this in his depo. What he means is you're trying to determine whether or not all the liquid is getting down into the zone it's permitted to go to and is confined there. And he's saying only way you can learn that is through pressure monitoring. And the second thing you can only learn through pressure monitoring is the integrity of the tubing casing annulus. And you've heard a bunch about that discussion today. Well, as you go through and you cross-examine Mr. Burleson, what you find out is that, and we all know it, the only pressure readings in this case are in the H10 reports. And there aren't any pressure readings on the memorial document that has the volumes injected. There weren't any other pressure readings that were taken in conjunction with the case other than after the blowout. I'm sorry, the surface breakout. Now, the problem with that for Mr. Burleson is that when he was being examined over on page 158 to 160 of his deposition, he acknowledges, and I'm going to get the exact language, Your Honor, because it's important. He acknowledges this twice. First at 108, I'm asking him about the issue, and this goes to the masking of the pressure by the packer. You may recall that came up in Mr. Foster, Mr. Hughes, but there has not been an expert in the case who has said the packer doesn't mask the ability to determine the well's integrity below it. Every witness has said that, including Mr. Burleson right here. First, at page 108, I asked him, would that packer, this refers to the packer at 261, would that packer have obscured the lack of integrity in the well? Depends on, I'm sorry, the well below it, meaning below the packer. Depends on how you're evaluating integrity. Well, that's evasive. Next question. Would have affected the running of a pressure test in that you were the only pressure testing down to the first packer at 260? And he answers, if you were under the right conditions, that is one of the possibilities, assuming, yeah. Okay, that's pretty gray. So we came back to talk about it again at page 158 to 160. And over on that page, I questioned him, and I started by saying, I think it's your testimony that the reason Grandfield passed the 5-year test was that by properly placing the 3736 packer, there was accurate pressure down to that point that was measured by this particular form H5. And he says, right. And then I go on to say, he talks about how you could do this at line 10. I guess what I'm getting at is when you run the pressure test with the bottom packer set at approximately 3736, the tubing string you're measuring only goes down to that depth to determine pressure, correct? He says, well, you're measuring surface pressure. You could measure it at any point, sort of evades it. Yeah, you could run a pressure gauge and yeah, check pressure every 100 feet or, and then I said, well, and I'm not making myself clear, I apologize. What I'm really getting at is that you can't measure the pressure any deeper by a pressure test when there's a packer set at 3736, that depth, correct? And he says you cannot measure the pressure between in tubing and casing annulus any deeper than where the packer is set. Below the depth of the bottom packer, answer, right. So what we know right now is that when they put in one of two illegal packers, the one at 3736, it masks the pressure from that packer down to the permitted zone. They can't measure that any longer because that packer masks it. Then we go on to talk about the upper packer over on page 60. Okay, I figured we'd finally get around to a yes, no on that one, but you would agree with me that absent abnormal or different special practices, you would not be able to measure the pressure in the tubing string below that 261-foot packer if it existed at that site and location. Answer, yes. Now, what that tells us, Your Honor, is that every H10 after the time the 260-foot packer and the 3736 packer were installed has the wrong pressure on it, because you can't measure the pressure of the entire tubing string when it's obscured and masked by two illegal packers. Everybody agrees to it. Mr. Burleson agrees to it. So, remembering his global statement, the only way you can measure pressure is by monitoring. The only way you can determine confinement and integrity is monitoring pressure. He can't monitor it because he has no accurate pressure readings. All he has are the H10s. The H10s are inaccurate across the board. Not only do they not show the location of the packer, not only do they not show the location of the second packer, but every pressure reading on there is made up or it's false because it doesn't measure the entire tubing string, and it can't, and Mr. Burleson recognizes it. So his opinions on whether or not things were confined, whether or not the well had integrity, and I might add, Your Honor, he makes those opinions in the opinions section of his report. And he concludes that the well, SWD5, was operating with sufficient mechanical integrity for confinement of injection from December 2010 until at least February 2012. Impossible. As of June 1st, 2011, everybody knew there were 2 packers in the well. So he can't make that conclusion. He says this is his opinion, despite what he just testified to. Number 2, the installation of a shallow double cup packer in the ejection tubing string of the SWD5 did not occur during the workover procedure. Well, we've moved through that. Then he goes to the third one. The installation of a shallow double cup packer in the ejection tubing string of the SWD5 would not have contributed to the loss of efficacy of the primary injection packer. And then he goes on to say, or interfered with the diagnosis of the loss of casing integrity based upon the well conditions. When he was questioned at his deposition, I said, what's the basis for that? How can you conclude that? And he said that it was based on the H10s. So Mr. Burleson cannot give opinions on the integrity of the SWD5 because the evidence that he reviewed, the factual basis for his opinion, is inaccurate. And the reason for that is he sets his own standard and says the only way you can determine this is by pressure. And then he has only H10s to look at for that pressure. And his own testimony tells us those are inaccurate because they couldn't measure pressure below either packer. In reality, his opinion about the 3736 packer being accurate, it can't be accurate because the 261 is above it. And that packer masks the pressure all the way to the bottom. The 3736 masks it from its location to the bottom. So he has no basis for concluding that the mechanical integrity of this was never affected and the like, and it should be struck. Now, the other portion, Your Honor, of all his opinions, and it's both in his report, and I guess that's the easiest way to go to it, is that he says at the start on page 3 of his report, and this is important because it takes up all 4 of his opinions that are of import. On page 3 of his report, which is exhibit 2 to our motion to exclude.
Okay. All right.
And this is really the last point I'm going to make right now. Is the court ready there, Your Honor? If you look at that number 4, he is taking up here, even though he said in the very first page, he couldn't determine causation because it's only, you can't put the dots together. It's only what's likely and possible. He decides to do so anyway. So in paragraph 4, here are his 4 opinions on what were the sequence of events that led to the surface breakout. Well, let's look at that second line. He's only telling us what typically occurs. That's irrelevant. That's insufficient. That modifies every opinion he makes thereafter in this section. So none of these have sufficient probability, certainty, and in fact, I have no idea what typically occurs means or how it's applicable. But look at what he then says. This is what typically occurs. Number one, loss of injection confinement due to Memorial's concentrated and aggressive injection operations in the Bront Field reservoirs. That's one. He says that typically occurs. I don't know how that typically occurs. I don't know how many fields Memorial's running, but he says that's typical. Then he talks about this really bogus notion of the Coleman Junction formation jumping inside the well and causing this. And what does he say about that? Communication to and pressure activation of the Coleman Junction formation above the Palo Pinto Reservoir, most likely through one of the many plugged and abandoned wells located in the Bronte Field, never identified, or an unmonitored well that was only partially cemented, never found or identified. So that's no opinion. It's only as to what's most likely. Now, there's one more evidence on the Coleman Junction that I'm going to bring up. And what you will see, Your Honor, and it's an exhibit to our motion also, is that, and this is exhibit D to our motion.
All right.
And what this is what's known as a fact sheet. And agencies regularly publish fact sheets on all kinds of topics. This one, you can tell from both the top and the very bottom of the internet date, comes from the U.S. Geological Survey. And I questioned Mr. Burleson, and he acknowledged the U.S. Geological Survey is the federal group that monitors where formations such as these are located. And he says this formation is in Coke County. Well, if we turn over to the second page of this sheet, and I might add, this is obviously a public record. It's an exception to the hearsay rule because it's what the USGS does in their normal course of business. They regulate this. And what they determine is they tell at the very top of that next page, the counties the Coleman Junction formation are in. And Coke County's not even listed. And that's what the USGS said about it. And I asked him about it, sort of, what do you think about that? And he just immediately said, like Ivory wrote in its criticism, that he just concludes, well, that's not right. And I don't agree with it. And that's irrelevant. And of course, none of it is. And this is the definitive document on where the Coleman Junction formation is. And he had no answer to it. He didn't say, oh, this, that, or the other. Also, Your Honor, we put into evidence the next exhibit, just so it's a little more vivid. And that is a color-coded map of Texas counties. And on it, the orange shows where the USGS says the Coleman formation is, and the yellow county is Coke. So Mr. Burleson, frankly, doesn't know what he's talking about. And he's wrong on that point. And he doesn't get to just wave it off. He doesn't get to declare ipsy dixit, I say it's wrong, therefore it is. And he has no way to address it. Now, that only goes to the fact that in this particular case, he's given these four opinions that we were just walking through. And one of them purportedly relies on this mythical interaction between the Coleman Junction formation and this particular well. No basis. Remembering all this is only typical. Let's go to his third opinion. Loss of mechanical integrity of the production casing string within the SWD5 wellbore. He can't make that opinion because he said the only way you can measure that is by pressure monitoring, and he had no pressure that was accurate to look at. So he can't conclude that. He says in opinion number 7 at the very bottom that pressure monitoring is the only method available to effectively evaluate maintenance of injunction confinement or the integrity of the tubing casing analyst. Sorry, Mr. Burleson, you don't get to give opinions on other causes, other evidence. He limits himself And then he uses evidence that's inaccurate. So he can't give that opinion. Number 4, communication with the surface in the vicinity of the SWD5 well to complete the conduit or fluid pathway. No idea what that means. I don't know what communicated with the surface. What we have are things coming up to the surface. So in any event, those are his opinions on the well, and they're all only typical, and none of them are meaningful. And then lastly, Your Honor, and this is indicative of it, we're going to look at the H10, that is the Exhibit F. I think it's the next one over. And this one's particularly interesting. You can see in looking at it that it involves well number 5, which is in the top portion of it over on the right-hand side, paragraph 11, says well number 5. These are the pressures and injections and the like that Memorial said occurred up through and including the date of the breakout. And of course, we have information that shows Memorial was injecting fluids all through this period, even though it says 0. And we also have evidence, of course, of Mr. Burleson acknowledging that he couldn't find pressure data that was complete for the last 2.5 years before the blowout. He testifies to that also in his deposition. So if we walk through the other HTIDs, we understand that they're about as accurate as Memorial's here. None of them have the correct pressure. The others actually put in pressure numbers, and those pressure numbers may have been read by people and they may have recorded them accurately. The problem with them is they don't measure the pressure in the well. They only measure it down to the packer. So Mr. Burleson, no basis for testifying, no basis for concluding any of these things he does. When you look at the rest of his opinions, Your Honor, I mean, you're talking about him giving opinions for which there is no support, that only typically might have occurred, simply insufficient to be permitted before the jury. And I think that concludes my response. He also suffers from using words like appears, impossible, can't connect the dots. He admits he can't give an opinion, then he gives opinions that have no basis. So his opinion should be struck.
Thank you, Mr. Addison. Mr. Terrell, are you up on this one?
Yes, ma'am, I am.
All right.
If it please the court, Your Honor, Mr. Burleson is a 37-year petroleum engineer and reservoir engineer, vast experience in all types of oil and gas operations, including saltwater disposal wells and breakouts. He graduated from Texas A&M in 1981 and has been actively practicing in petroleum engineering and reservoir engineering from that standpoint. No one, Your Honor, will ever know what absolutely and actually caused the breakout and at what interval. We can't look down a wellbore nearly a mile down and make that determination, especially when there was no real evidence that was brought out of this well after the breakout. Mr. Burleson, and it's easy for us lawyers to criticize these experts that have been dealing with it for years and just say, well, that's ridiculous. But you know, they have a little bit more science to it than just saying that it is because Mr. Burleson, and he testified about this in questioning with Mr. Addison, all his experience in litigation. And one particular piece of litigation was a case of Occidental Permian versus Oni. And I had the misfortune of representing Mr. Oni and the saltwater disposal facility. And Mr. Burleson was the expert for Occidental Permian. And what had happened in that case, which gives him some unique perspective about cause and effect, is that somebody pulled up to Mr. Oney's saltwater disposal facility in the middle of the night. And although it's monitored by TV, they dumped about 50 barrels of drilling mud directly into the pump. Well, when that drilling mud went in, the pressure went off the chart. The Gardner Denver pump shut off, but the damage had been done. It ruined the pumps, it ruined the saltwater disposal well, and that was kind of the end of that story until Oxy sued the Oneys, saying your saltwater disposal well ruined our new development well 2 miles away in the West Levelland unit in Hockley County. And we thought, preposterous. How can that? I mean, that is stupid. That'd be the same thing. Your opinion is stupid. Well, as it turned out, what had occurred is the placing of the drilling mud into the well fractured, and water then began migrating along the path of least resistance to the Oxy well, and it did it long enough, and it collapsed the casing. They ruined the well. So we all know, and Mr. Burleson from first year geology, that below the surface are numerous stratus to the center of the earth. Some of those stratus have more porosity and permeability, which allow water and oil predominantly, hopefully, to come in, and so you're able to produce it. And there are, in first year geology, describe it as other sands and stratus that are like mini rivers underground. And that's why you have to put surface casing in the well to protect fresh water, and also sometimes casing down to the production zone to keep out these unwanted rivers of water. So Mr. Burleson has a different approach, as he certainly, any expert, none of the experts, Mr. Colonel Foster said the same thing when I asked him, do you really know what happened? No, we don't know. But there are some hydrostatic conclusions and opinions that can be made. And here's what Mr. Burleson really says. First and foremost, he disagreed with Mr. Addison because the USGA first page that he handed him didn't have Coke County in it. And Mr. Burleson disagrees with that, and he has some real reasons for that. He produced, in response to Deuces Tecum before his deposition, hundreds of pages, including, interestingly, a Rule 37 permit by Exxon regarding the Bront Unit 118 well, wherein Exxon found the Coleman Junction in that well. There are also scout tickets from far back as Sinclair Oil and Humble Oil showing the Coleman Junction in the Bront field. So whether it is or it isn't, and it's not in the USGA, Mr. Burleson says there's outcroppings of nearly every formation underground all over this world, and that the Coleman Junction just happens to be that outcropping. Whether it's called that in the USGA or not, it doesn't matter. There is water, a river of oil underneath in the Bront field, and Mr. Burleson says a likely cause of this loss of mechanical integrity is at the same place that it lost mechanical integrity twice before and required a squeeze job. And interestingly, under the Wellbore diagrams, it's just about in the same junction at about 2,350 feet, something along those lines. So he's just not making this up. This is something that he testified often happens with saltwater disposal wells as they are exposed for a long period of time to a corrosive form such as saltwater, brine water, and that sort of thing. The interesting thing and the importance of Mr. Burleson's testimony is his idea, and he proves this way, that At the time of the breakout in September of 2014, Your Honor, the tubing string was intact. And everybody says, well, how do you know that? That's impossible. Well, he knows that because he did look at the prior H10s. If you disregard the H10s from 2010 forward, say that Mr. Addison is correct and the double E packer matched the pressure, then throw them out. But he went back to years prior on the H10s in this particular well, and it acted the same way that it always did. And that is, when you shut the well in and then turn it back on, it took water on a vacuum. And the same thing occurred in this well, according to the Railroad Commission records, on September 27, 2014. That's exactly what the workover with the Railroad Commission monitoring is. This well was shut in. This is after the breakout. There's water flowing everywhere. But after the breakout and they shut it in, it reported 0 injection pressure. It was taking water on a vacuum. Now, as in previous H10s, once the well's turned on, it's not going to take water forever on a vacuum, and then pressure will start to build up, and hopefully within the injection pressure allowed by the Railroad Commission. But the importance of it is this: when he says in his opinion, he says that there was mechanical integrity of the tubing string in September of 2014, and therefore the injection volume, injection zone did not communicate with the annulus. And he knows that for a fact for this reason. This breakout, he believes, and the basically the physical evidence and the science would support it. If this came from the produced water in the Bront number 5, and it came out from the injection zone, what would be the pressure on the tubing? Well, it wouldn't be 0, because the water would be coming up the tubing with hydrostatic pressure. And we've got to remember that the Model R it's like a donut. It's about this big. It's very small and it has a hole in it. And it goes down and it turns to the left or to the right, and that seats it in the casing. And of course, between the tubing and the casing is the annulus, and that should have 0 pressure. And that's what this Model R packer, it likely could have masked the pressure on the annulus, but not on the tubing string. And that's what Mr. Burleson is testifying about. I can measure the pressure in the tubing string, and I can determine pressure at any point in time on the tubing by hydrostatic formulas. And I listed it in our response, and it's way over my head, but the engineers can do that. All they have to do is find one pressure point and then depth, and they can figure out pressure. But in this case, he didn't have to do that, because the Railroad Commission showed that this well was taking fluid on a vacuum with 0 pressure. And by his expert opinion, based upon physics, pure physics, the tubing string was intact. Otherwise, if the tubing string had communicated with the annulus and the water zone wherever, then water is going to come up the tubing. It's like putting a straw in a glass of water. You stick the straw in, and equilibrium reaches. Water comes up the straw, and it will equal out with the volume or the level of volume in a glass. The same thing in this case. If they maintained at the time of the breakout and after the breakout, the tubing is still intact, it did not communicate with the water zone or any fluid in the annulus. So there is a scientific reason why Mr. Burleson's opinion is important, because was the breakout due to produced water, or was the breakout actually zone water, either Coleman Junction or someplace else? And that may not be important to the Lees, honestly, because they still suffered whatever damage they suffered. But it is regarding the cause and effect in this case of what happened. And so from that standpoint, the fact that the lawyers don't understand what the engineering opinions are doesn't make them inadmissible. It actually makes them much more reliable than someone just seeing water percolating up off the ground. So we believe that based upon what Mr. Burleson did in his studies are admissible, and they meet the Robinson-Dahlberg and the 702 standard under Texas law. Thank you.
Any of the other defense counsel need to add anything?
Not Ivory, Your Honor.
All right, very good. Mr. Addison, anything further?
You're on mute.
Oh, Mr. Addison, you're on mute.
I think we're spending a whole lot of time on this Coleman Junction nonsense when the opinion only says this is what typically occurs or might likely occur. But that opinion is also based, Your Honor, when you look at it, on something like it moving through, most likely through one of the many plugged and abandoned wells, none identified, none determined, or an unmonitored well that was only partially cemented. Didn't find one of those, no basis. He's just throwing out speculation. It's in the form of speculation. As to the notion that the Coleman Junction formation was present there, even if you accept that, there's nothing that shows the Coleman formation had any impact on this. I might add, the Railroad Commission didn't jump out and say, oh my goodness, it's the Coleman Junction formation again. They said there were 2 illegal packers in this thing and it came back up the Wellbore and it came up out of the ground 500 yards away. No mention of the cause being any of this stuff they're throwing out there. Now, lastly, Judge, you know, and this is all over the law, you're the gatekeeper. And there's all kinds of admonitions in these cases involving experts about how prejudicial and unsupportable expert opinion can be, and how it's important that these opinions be, whether they're admissible or not, be determined very carefully because of their effect. And that's why all these rules have been set up that we cite to you in the motions that say, not only does it have to be certain and probable, it has to be based on reliable testing. There's none of that going on here with the defendants. Nothing about this guy's report shows he has a basis for any of this. He doesn't even say it. He admits at the front, he doesn't have an opinion because he can't figure it out. Not only can he not connect the dots, but he's saying this is all that's likely or possible because he doesn't know exactly what happened. This isn't a question on the burden. It's a question on who's allowed to testify. He doesn't get to testify on that. He tied his opinions to the H-10s. The H-10s are inaccurate. The language of his opinions is insufficient. He doesn't have a basis, it's speculation. So we would just caution the court with respect to these stories like the Oxy case. Well, that's great in the Oxy case, and those are all wonderful facts. We'd have to go figure them out. It's not like we can go superimpose that case and what happened here at the Cedar Mountain Ranch. So when we look at the real evidence and we look at the real opinions in this case, we find out these are inadequate. Mr. Burleson, I commend him for at least being honest because, you know, once again, he was asked, you're really giving us an opinion on these possibilities and likelihoods for causation, but you haven't been able to conclude exactly what caused the surface breakout. And he answers, that's correct. So he doesn't get to give any of the opinions in number 4. Those all go to that, and he's already admitted he doesn't know enough. So, Your Honor, these are all tough issues, and we appreciate the courts struggling with them with us. And but these experts are not satisfying the test. Their principal opinions aren't admissible. These aren't us nibbling on the edges. We're talking about the bedrock opinions that they plan to put in to try to attack the case. neither Ms. Moore's nor Mr. Burleson's nor Mr. Wheeler's have sufficient support. So we move once again respectfully to strike all their opinions and to strike their all of their reports.
All right, thank you. Whew, that takes care of us on the expert. Now,
Well, Your Honor,
yes, ma'am.
there is one more. I refiled a motion to strike some of the opinions of Mr. Hughes.
Okay, hold on.
Of Mr. whom?
Hughes.
Oh, Hughes.
The one that may be the order. There was one that I'm not sure we actually got y'all an order setting hearing. I refiled. What was that Renee brought in during lunch? Is that it? Did you submit an order setting hearing on that and it did not get signed?
No, that was for our motion to compel.
Okay. Thank you. I knew there was something. I actually signed that order, but Renee didn't manage to get it out because we had, what day is today? Thursday? I think I signed it Tuesday among them as I was plowing through from about 8:30 to 5:30, almost 100 felony pre-trials. It's been a broad week. This is what general jurisdiction looks like. So that we can go up. Now, let me find, when did you, on Ms. Hughes, where is the motion? Did you overnight me one of those, or was that emailed to me?
We filed that one on September 27th,
I had that one.
and
I printed it.
I'm assuming that far back that Sharon went ahead and FedExed it to you, Your Honor, but I honestly don't know.
What binders I have up here. Everyone take a stretch your legs break while I go through binders. Yeah, y'all give me a second. I'm going over to council table in the courtroom to see if I can find it. Don't trip over the courtroom.
Strike in advance.
I don't think so. I think I brought that one in here. Let's double check and make sure that Renee doesn't see it in her office. All right, I unfortunately cannot find the binder, but give me just a moment and I bet I can find the electronic copy of it. So there's filed on the 27th.
Yes, Your Honor.
We'll get there. Do not worry. It is probably on my desk. All right, we will do this. I cannot quickly find it, but Cindy, are you doing okay? Okay. Do y'all need a break? Or are y'all ready to keep moving?
I'm ready to go if that's okay with the court.
Fine with me. And we will track that down. If I need to, I'll try to pull it out of Research Texas. I'm confident it is at the courthouse. It's just probably got set in the wrong stack of binders on this case. And so it didn't make it into the courtroom for me. And I have got screen share on, so you are welcome. If you have anything you want to show me out of it, you are welcome to put it up on screen, Ms. Oscarson. And you may proceed.
All right, may it please the court, counsel. We deposed Mr. Hughes on September 16th, 2021. And at that time, Ivory had co-designated Mr. Hughes as one of its experts. We got into the deposition, and my recollection is, and although I don't have his transcript pulled out, my recollection is that Mr. Addison took a breath and that Mr. Hughes then volunteered, "Would you like to hear my conspiracy theory?" And of course, Mr. Addison said, "Well, sure." And so then Mr. Hughes proceeded for the first time to give us his conspiracy theory, which is that Ivory put the double E packer in the hole. He had reasons why he said he thinks Ivory did that. One of them is that he thinks that Ivory's owner, Kerry Crottinger, bought the SWD5 and only kept it for 5 months, which he said was suspicious. Actually, Mr. Crottinger's entity, Nyala, bought the SWD5 and the whole lease sometime before Ivory took over operations in 2011. And Nyala only sold the whole field, not just the SWD5, but the whole lease. When Boaz's owners contacted him, his testimony was out of the blue and offered him a sum he couldn't refuse for the field. And that's the reason that he sold the whole lease, obviously not just the SWD5. So that basis for his conspiracy theory is just factually wrong. Another reason he thinks that that Ivory put the double E in the hole was that he believes that the SWD5 experienced a, quote, major malfunction in late February 2011, which he says caused it to be shut in from February to June 2011. However, Roger Herring, who worked for Ivory at the time, testified that the well was in operation the whole time Ivory operated, certainly through when it transferred operations on July 31st, 2011, the SWD5 was never shut in. So that basis is just factually inaccurate. Hughes said he thinks that the SWD5 got pressure at the surface, so a workover had to be performed in 2011. Like I just said, Herring testified the SWD5 was never shut in, and there's no evidence whatsoever a workover was done on the SWD5 during Ivory's operation. Hughes says that he thinks that Ivory thought the only way to get the SWD5 to hold pressure was to set a double E packer in the well. There's no support for this whatsoever. He also says that he thinks that when Forbes was done with their workover in 2010, that 9 joints of tubing were laying on the ground. So Ivory took those 9 joints, put a double E packer on the end of it, and stuck it in the hole. I mean, there's no support for that whatsoever. He also said that he thinks Ivory was having buyer's remorse for having bought this SWD5, and so they found Boaz to take it off their hands. Again, Mr. Crottinger testified that Boaz called him up out of the blue and offered him money to buy the whole field, and he apparently believes the SWD5 is one saltwater disposal well of this entire lease, and so that doesn't even make sense. Mr. Hughes' opinions regarding Ivory are not reliable. They cannot be relevant. He admits it's a conspiracy theory. His quote unquote basis for his opinions are based on what are just untruths. He admitted when I cross-examined him on the fly that he had read those depositions that contain those facts, but either he didn't remember them or didn't consider them. And other than that, there's nothing to support what he thinks. And so without belaboring it anymore, Your Honor, I hope that we have actually sent you our motion, and if not, we will get you a digital copy ASAP, where we set forth the Daubert and Robertson factors that the court is very well aware, but we ask that you do not allow Mr. Hughes to testify to his conspiracy theory about Ivory.
All right, thank you. Plaintiff's counsel? Can you respond?
Yes, Your Honor, I'll handle this one. Your Honor, I am shocked that you're hearing this argument play out. What Ivory is saying is, previously, Jeffrey Hughes said Granfield did it. Jeffrey Hughes gets in his deposition and for the first time says, no, I have a conspiracy theory. Ivory actually did it. On this notion that people are somehow shocked at how anyone could have come to the conclusion, given that CC Forbes didn't install it, but nonetheless, it happened on Granfield's watch. That's what's playing out here. You have two defendants who are now turning on each other and pointing the finger at one another because they both know we have a fixed period of time, December 20th, 2001, June 1st, 2011. Two defendants operated within that time frame. One of them definitely did it. Initially, Jeffrey Hughes said it was Granfield. The person who was candidly, this will come out, was paying his bill at that point was CC Forbes. Is that the case? Granfield is now paying his bill. And now he says Ivory did it. So let me walk you through some things, Your Honor. If I'm going to share screen. Are you able to see the August 6th, 2021 deposition of Mr. Foster, Your Honor? Your Honor, are you able to see that?
I can.
Okay. You recall, we got a little bit animated, and first I apologize, Your Honor, if I seemed out of line this morning and responding to some of the things that Granfield and Mr. Terrell were saying. Ms. Oscarson, I think she chimed in and said, oh, I was at someplace with a daughter and I read something and my jaw dropped.
Hold on. No. First and foremost, let me tell you, no one thinks you were out of line.
Oh, okay.
My court reporter just thinks you were talking too fast.
Thank you, Your Honor.
Doing it again. So
All right, so I will take care of that.
I have an outstanding court reporter, but she can only take down so many words a minute. So
I'm taking a deep breath right now. So the arguments that you heard from the counsel was that they were shocked at the notion that in this recent filing, we made clear that Mr. Foster is not opining that CC Forbes installed the EE Packer. This is his deposition, August 6, 2021. Mr. Terrell was a primary counsel questioning Mr. Foster. On page 78 of the deposition, the capstone of Mr. Terrell's questioning. Fair enough. And my final question right now, I'll let somebody else talk to you. Is at least we know, based upon the sworn testimony of Raul Baltazar spelled wrong, that CC Forbes didn't put an EE Packer, according to Mr. Baltazar, in that operation on December 10th or December 20th, 2010, right? Mr. Foster's response, yes, according to his testimony. So the defendants, because they asked, have known since at least August that that is not Mr. Foster's opinion. But contextually, the reason that this is important relates to Jeffrey Hughes' opinions. And this is actually exhibit number 23, Your Honor, to the response to the summary judgment motions. So we've covered this before, but it is taking on greater import because of some of the positions that the defendants are now articulating. Mr. Hughes went through an analysis, and we've done this before, Your Honor, so I'm going to try to be brief. But there's a part that we had not historically focused on. He talks about the timing of the EE Packer in the SWD5. And then he goes through kind of his analysis and understanding of what happened. But what he also did, Your Honor, was to offer commentary on Jason Foster's initial conclusion that the CC Forbes field ticket had documented the installation of the EE Packer at 260 feet. And he tells us that's what he's doing. I have reviewed the technical memorandum, in this case, of plaintiff's expert, Mr. Foster. He says he disagrees with Mr. Foster. Okay, he'd already offered, Mr. Hughes had his understanding of what happened. I'm going to circle back to that. And so now he's saying why his perception of what had happened differed from Mr. Foster and why he thought Mr. Foster was incorrect. So he goes through that analysis. But here's the key part, Your Honor. He points out that Mr. Baltazar, this is his correct spelling, had testified after Mr. Foster submitted his report. And Mr. Baltazar, who was present on December 20th of 2010, under oath said, yeah, no, we pulled the well. We know what was happening. And no, we didn't there was no packer in there when we pulled the tubing out. So that's another one of our timing benchmarks. There are all kinds of well records that don't show a packer prior to December 20th, 2010. This is somebody who eyeballed it and said, when we opened that well and we pulled out the 8 streams that adds up in total to 260 feet, there was no packer at the bottom. So that's a hard beginning of this packer phenomenon. Baltazar testified to that. Mr. Hughes knew that Mr. Foster had not been able to consider this testimony that came after Mr. Foster gave his opinion. And so he says, fairly diplomatically and to his credit, with a great degree of gentility, I believe that once Mr. Foster takes into account the deposition testimony of Raul Baltazar, he will agree with me that C.C. Forbes never placed a model EE packer in the Bronx number 5 SWD5 well, and that Forbes is not to blame. So you know what we had Mr. Foster do, Your Honor? Read Baltazar's deposition testimony. Read another gentleman who was on site named Javier Murillo's deposition testimony. Look at all the peripheral information out there. And he then complied with his duty, and certainly our duty as officers of the court, to say, you know what? Like everybody else in this case, we initially read the field ticket to suggest it was actually C.C. Forbes who physically installed the packer. But based upon an analysis that tracks with Mr. Hughes, we now have more information, and we know there's no longer any evidence to support that conclusion. So I just thought that as a matter of convenience, since we now are having to broach this subject, I would give the court a little bit more context. But to now sharpen the focus on the import of this tension that's now evolving between Granfield and Ivory about which of the two is the answer to the whodunit mystery, the reason that that is so important to them, Your Honor, is because Mr. Hughes' initial opinion, which he's now trying to back away from with his conspiracy theory, is that it was Granfield who did it. He talks about this process, Your Honor, where the people, the workover crew, nobody disputes this. C.C. Forbes did pull out 8 joints of tubing. They laid it on the ground, Your Honor. And when you pull those tubing up, you're physically lifting the height of the well. And so the well that was already inappropriately located was even more inappropriately high when C.C. Forbes pulled it up, put the stuff on the ground. And what the field ticket shows, what Mr. Baltazar testified to, what Mr. Murillo testified to, C.C. Forbes at the end of the day on December 20th, they just closed the well and they left 8 joints of tubing laying on the ground. So we now have a well that is well above the regulatory limit. It had always been above the perforation zone where it's legal to push the water into the formation. But now it's well above anywhere that's considered legal. And so it can't stay in that location. This is Jeffrey Hughes giving this opinion. And so what somebody ultimately had to do was to stuff those 8 joints of tubing back in the ground. And so Mr. Hughes says, when that happened, that's when the person installed the double shaft, not C.C. Forbes, but it definitely was installed, the EE packer to drop the well back down to a only moderately improper level, as opposed to the comically improper level that it was left at the end of the day on December 20th. And so what he then says, Your Honor, and this is the key part, records in this case seem to indicate that the workover was done at some point before June 1st, 2011. And now he's specifically referring to the installation of the double E packer at this point. So this expert has now completely brought into these bookends. December 20th, in the morning, it was not there. But what's for certain is that by June 1st, 2011, it was, because that June 1st, 2011 document that 3 witnesses for Ivory have now testified Ivory created, it accurately documented the location of the well. Now we've probed Ivory, and again, Your Honor, I know I'm being redundant, but it's only because the defendants are taking positions that have to force me to revisit this issue, because we covered this in the context of the summary judgment response. We have probed Ivory, and Ms. Oscarson, I think, is absolutely right. We have said, give us everything and anything that will help us determine whether or not Ivory was the person who installed that shallow packer sometime between December 20th, 2011 and June 1st, 2011. And there's nothing to suggest that. But we know it happened, and there are only 2 potential culprits. And so the notion that there's no evidence, or that, you know, somehow the complexion of the case is dramatically changed, and I'm shocked and appalled that at the last minute the plaintiffs would, pull the rug out from under the rug from out under us. Respectfully, Your Honor, that is nonsense. Mr. Naddis and I actually talked, and we think that it may be most appropriate to allow us to respond to Granfield's motion of reconsideration, where they're raising the suggestion that the recent filing that merely restates what Mr. Foster articulated back in August somehow warrants the court reconsidering the summary judgment, to perhaps allow us to submit briefing on that before the court takes up this challenge to Mr. Foster, so that you'll have a comprehensive record of this. But the point here is that I'm stopped. We don't necessarily take a position with respect to the strength or the prudence of Ivory's request to strike Mr. Hughes. We, however, think that this illustrates compellingly why it is not credible for anyone to be suggesting that the status quo of the case is any different today than what it has been for months, or that there are genuine issues of material fact as to whether or not Granfield did it or Ivory did it, and neither one of them are entitled to summary judgment dismissal of our claims. These issues should be presented to a jury.
All right, thank you. Ms. Oscarson, anything else?
Just briefly, Your Honor. Yes, I was shocked to read that the plaintiffs now concede CC Forbes didn't do it. It seems like that they're saying now, well, Baltazar testified, and so we've known all this time he didn't do it. But the plaintiffs have filed who knows how many briefs and motions, and their live answer claiming that CC Forbes did it after Mr. Baltazar testified in 2019. So no, and maybe I don't pay good attention, but I did not know until I read that yesterday morning that they were saying CC Forbes didn't do it. With regard to Mr. Hughes, though, it doesn't sound like the plaintiffs really contest our motion to strike Mr. Hughes's conspiracy theory. And so I will ask the court that you please do that.
And let me see, was there anyone, Mr. Terrell, are you the one now proffering Mr. Hughes?
Well, Your Honor, I can be clear on that. I cross-designated Mr. Hughes for 1 point and 1 point only, and that was his original opinion that CC Forbes did not install the double E packer. That's it. That's all. I don't think Mr. Hughes said Granfield did it. He said it was installed after December 21st, 2010. That's no big deal. But with respect to what he came up with the other day at his deposition, number one, that was not in his initial report. And number two, it was unsolicited. So I agree with Ms. Oscarson that, it's not Granfield and Ivory throwing rocks at one another. That's clearly wrong. We just didn't know about it. It wasn't in his report, and therefore it's not a proper opinion.
Let me go back to Mr. Knight, because we talked quite a bit about Mr. Foster as to the conspiracy theory. what's plaintiff's position? I mean, are y'all taking the position that he should be able to give that opinion at trial?
Your Honor, our position, frankly, and I don't want to sound like I am deflecting. Our position is we're going to press him pretty hard if he does take that position at trial, because we think he had everything else he says. We think it's credible. What happened on the day of, why they had to put the tubing back in, how the Packer got in, the timing, that's credible. But if he's going to now switch course because the person who seems to be paying his bill, it would be to their great disadvantage for him to take his original position, where we're going to take that up on cross. But we candidly don't necessarily have a strong feeling because he's pointing to one of the two defendants, and that ain't all bad from our perspective, to be honest with you.
All right. I'm going to order that Hughes cannot give these conspiracy theories on the basis that they appear to lack factual background and it was not included in his report. So Ms. Oscarson, if you will get me an order to that effect, I'll get that signed. All right. Now, does that take care of all of the expert motions that y'all anticipated we would hear today?
Your Honor, one last point of clarification. Do we understand that's the only topic on which Mr. Hughes is not going to be allowed to testify? Is this one of his so-called conspiracy theory?
That's the only thing that I heard raised in the motion by Ivory. So sounds like nothing else challenged. All right. Now, we did have, and I was hoping to hear Ivory's second motion to compel today, but I don't know, since Renee did not manage to get that notice out, are y'all prepared to have that heard today?
No, we're not.
We got a lot going on up here with me being down one court administrator. Okay, so y'all are going to continue working on motion in limine. You're going to continue working to narrow down what exhibits may or may not. And of course, if there's exhibits that are not agreed to, we can either take that up pre-trial, or we can, that can come up during the course of the trial as far as if it's admissible. But I appreciate y'all working on agreed pre-admission exhibits. And then there are multiple objections to particular deposition excerpts. Do y'all want to address those today, or would y'all prefer to call it for today and we try to find y'all a time slot next week where we could have maybe just an hour or two to wrap up on these last few details? We also at some point, we've got the motion limiting in the works. So y'all tell me what y'all like to do. Y'all been going at it pretty hard today.
On behalf of the plaintiffs, Your Honor, we're of course ready to move forward on anything the court really thinks we should. I think, like the limines and like the exhibits, we would benefit from a session alone together where we sort of tested the reality of those, and we've worked pretty cooperatively on limines and exhibits. So I would suggest, before we take the court's time, we make a run at that. It sure sounds like we're going to need another pretrial somewhere maybe like middle of next week. And that would be the plaintiff's suggestion. And I want to add that I am perfectly fine with stopping today and punching the leave button as soon as the court tells us.
Well, as much as anything, that would give me the opportunity to go back in my office with a little bit of the day left to just work on some of these, because I know critical things that y'all need from me are some rulings on these motions today. Anyone else have a problem with us finding a time slot? And I'm opening my calendar is what I'm doing. Finding a time slot next week where we could reconvene and look at these last remaining issues.
No, Judge, I will give you one update. We talked about the tech side of it at the hearing on Monday. I received a text from my tech guy today saying that COVID is affecting his ability to get some of the equipment he needs. So we're working on it. We hope to be able to do what we said we're going to try and do. But as of now, I think they're all sitting on ships outside of either Galveston or California.
Okay.
We'll talk with our folks and see if there's some way we can come up with some equipment. And we'll work together on that.
Sounds good.
Yeah, y'all work together, because like I have said, as long as Ms. Wilde has exhibits in the form that she wants, which is printed, y'all can put them up electronically. Y'all can bring blow ups on foam core. Whatever works for y'all will be fine with the court. I don't have a problem. Okay, it looks like I have a very full week next week, but it looks like we could probably squeeze y'all in if y'all are agreeable to start a little bit late. If we started at about 3:30, got a divorce that's set for 2 hours starting at 2, but I will just move them along. We could start about 3:30 or even 4 o'clock on Wednesday, the 13th. I am jammed up with pleas all day Thursday, and Monday is a county holiday for my staff. And then Tuesday is, I'm full up with Erie and Schleicher counties. So Wednesday may be about as good as it gets unless we do it Friday afternoon after I hear temporary orders.
We prefer Wednesday, Your Honor. I assume we're talking about a Zoom hearing.
Yes. Wednesday
We'd
afternoon.
be prepared to go late in the day Wednesday and are at the court's convenience.
Would 3:30 or 4 o'clock on Wednesday work for everyone else? Anyone, let me ask you this way, anyone have a problem with that?
No, Your Honor.
Okay, all right. When y'all, I know y'all were trying to do one more mediation. When is that set?
Monday or Tuesday. I don't know that it's
Okay,
firm yet.
excellent. And y'all had a deposition yesterday, and y'all have one more real estate appraisal deposition to be scheduled. Are y'all still working on getting that done?
Yes, we are, Your Honor.
All right, very good. I will go back in my chambers and get to work on trying to get some rulings out so that y'all have some clarity there. And we will get y'all set. It may very well be 4 o'clock on Wednesday. That just may be easier for us to schedule. Cindy, OCL, either one of y'all have a problem with working late Wednesday? We'll be on 5. You're in San Antonio. We've got Tanya bailiffing. Of course, I can just close the doors, lock up, and go on YouTube. We'll plan to do that. Okay, so we'll do Wednesday at 4 on the 13th, and I'll try to get rulings out. Y'all keep at it. Let me know if there are any developments. The clerk's office, I think, are y'all getting the scanned copies of questionnaires that she's sending out?
Yes.
I'm so sorry. She can only send, I think, one questionnaire at a time. If y'all have a staff member that y'all would like for her to send those to, feel free to email her and have them send them to a paralegal or a legal administrative assistant instead of to each of y'all, if that works for y'all. I have no problem with that, and she'll be happy to do that. And I have not even had a chance to look at all the people wanting to be excused. So I will be working on that in the next few days as well. All right. Thank y'all very much. We are concluded for the